We want to turn our attention now to Minnesota, where prosecutors in the Derek Chauvin murder trial are asking Judge Peter Cahill to sentence the former Minneapolis police officer to 30 years in prison. That is twice the upper end of the presumptive sentencing range for Chauvin's second-degree murder conviction for the death of George Floyd. On the other hand, Chauvin's attorney, Eric Nelson, is asking the court to only sentence him to probation and time served. Trial attorney Jamie White is still with me. Probation and time served. Let's start with that and what your thoughts are when you hear that.
I think that's a mistake on the part of Mr. Nelson. I thought he conducted a really good trial, but I think this is a mistake, Judge, and maybe you can speak to this more so than I can, but anytime I see a defense counsel in whatever context ask the judge for something that is completely unreasonable, I think it almost destroys credibility, and any argument you make after that unreasonable request is tainted, you know? So I understand why he did it, but I think that idea is so preposterous. So he knows he's going to prison. The way to approach it would have been to suggest, I know there's going to be consequences, but we're going to argue for the lesser end of those consequences and let probation be inferred, I suppose.
It's, I was a little surprised when I heard it as well. And I also wonder, and maybe you can answer this better than I, when you have a defendant, who gets to decide what I'm going to ask for? Is that something that's up to the attorney to say, this is what we're going to argue for? Or does the defendant get the end say? And could the defendant say, I don't care what you think, attorney, on how to handle this strategically, I want to ask for probation?
Yeah, so it's my opinion that the only decision that the defense really has is whether or not he's going to testify. It's up to the defense counsel to put forth the argument that he believes in the best interest of his client. Now, with that said, there's nothing unusual about a criminal defendant saying, hey, I want you to ask if when there's not a prison sentence, I want you to ask if I can do tether instead of jail. I want you to ask if I can, maybe turn myself in a month later. Those are very reasonable requests under certain circumstances. But in a situation like this, if Chauvin demanded probation, it's up to Mr. Nelson to explain to him why that could potentially hurt his argument. Because I'm presuming they're going to go into his history of law enforcement, all of these things that are very credible arguments to be made. And to argue for probation, I think is going to fall on deaf ears.
And he's been convicted of murder, after all. So I'd like to take a look now, and I thank our producers who have put together, we have what the state is respectfully requesting, as well as what the defense is requesting respectfully in this case. So we're looking now on your screen. You can see the state specifically requests a sentence of 360 months. Again, that's 30 years for the defendant, Derek Chauvin. And in this case, that is for the conviction by a jury of second-degree murder, third-degree murder, and second-degree manslaughter. And that is right there, an actual picture of what the state has submitted. What I'd like to then compare that to and contrast that to, really, is that Mr. Chauvin respectfully requests that the court disregard its Blakely findings and pronounce a strict probationary sentence along with a period of incarceration equal to the time he has already served. And I'd like to focus, Jamie, on that part, equal to the time he has already served, because in some cases, by the time you get to the trial and have a conviction, they may have spent 7 years in jail, 8 years in jail. Theoretically, that shouldn't happen, but we've all seen it. And when you ask for time served and it's been a long time in jail pending the trial, that's a little bit different. Here, as we all know, this happened a very short time ago, relatively short time ago, that this man has been in jail. So do you think that it undermines, I know you've already mentioned credibility, and does it here's what I fear for the defendant in requesting this, is that it makes it sound like he does not believe he's accountable for this murder, that he doesn't have a responsibility in this conviction to be held accountable and serve time in jail.
I agree with you. It's not only preposterous, but it really is offensive to the court and to the victim's family, and really to the community. And I know maybe the community's had too much of a focus in the sentencing, or at least that's what I've heard. People are concerned that maybe the community is going to come into the court's mind. But at the end of the day, it is the judge's role to issue a sentence that's proportionate and will deter people from further actions. And he is going to do something beyond 12 and a half years. I don't think there's any question about that. That was the first time I've seen that document, Ashley, and the sentence that really stood out to me was asking the judge to basically disregard his Blakely findings, that he was wrong, or he should overlook them. And I believe he found that at least 4 or 5 of those were, he was culpable under that statute, and for at least 4 or 5 of those factors. So it wasn't as if there was just one minor thing. So he's going to deviate behind the 12 and a half years. Does he go to 30? In my opinion, that might be a little heavy-handed. We were predicting 20 based on our evaluation of the sentencing guidelines.
Right. And just to mention the Blakely aggravating factors that you mentioned, one of them, for instance, was his abuse of a position of trust and authority as an officer, or that he treated George Floyd with particular cruelty, and you see the rest there on your screen. So I agree with you. These are the Blakely factors. Children were present, committed the crime with active participation of at least 3 other persons. All right. Thank you, Jamie, because there's going to be a lot to talk about that as it moves forward.